Good afternoon, everybody. My name is Elena Mishra. I'm a barrister at Old Square Chambers. And first of all, I would like to apologise to all of you that I'm not there at the FiLiA conference in person this year, which is a tremendous shame for me more than anything else. There are a good many of you that I was hoping to speak to, listen to, and hopefully even catch up with over a drink at the bar. But I hope you've been having a wonderful time at the conference. I was very pleased to be asked to contribute to the legal panel today. The topic that I wanted to talk about, because I do think it has a particular resonance and significance for women, is flexible working. And it seems to me that at this point in time, as those of us who practice in employment and equalities law, as I do, along with a number of my colleagues who I think might be there today, it's very clear that the overwhelming majority of cases that are pursued in the Employment Tribunal, either in relation to requests to work flexibly under the flexible working regulations, which I'll come to, or alternatively as indirect sex discrimination cases, are brought by women. And the simple fact of the matter is, as was noted by the Employment Appeal Tribunal quite recently, it is a matter of which judicial notice can still be taken, that the lion's share of childcare in this country does tend to be, or is in fact, taken by women. And it is a bit chicken and egg insofar as, so long as childcare, the rearing of children, the taking of time off work when a child is poorly and someone wants the child to be collected from school or nursery, when those matters are seen as being a woman's work, and when perhaps due to economic inequalities, we're seeing that the disparity of incomes between men and women is such that sometimes it is women who tend to take on the lion's share of childcare instead of potentially progressing in their careers at the rate or in the manner that they would like. So long as that remains the case, we are going to see a real problem in the workplace. First of all, in terms of retaining skilled individuals who happen to be women because of these childcare issues, because in the main, they are best dealt with by some form of flexible working. And secondly, as new generations become more alive to the variation in practices between employers, we're going to see that those workplaces in which flexible working is not only given proper attention, but actually embraced, are not going to attract the best calibre of employee in any event. But it is important that we don't just see this as an issue that we need to fix for women, because flexible working, so far as I and colleagues who are also working on this, both at the Bar Council and in chambers, as far as we see it, unless we establish a regime of flexible working for all, so that's men and women, and indeed people with other protected characteristics, for example, disabled employees, younger employees, older employees, those with different sorts of caring responsibilities, unless we have flexible working as a norm across the board, it will continue to be seen as an issue for women and hinder their progress. You may or may not be aware that the government has recently launched a consultation. It launched it in September. The title of it, it's the Department for Business, Energy and Industrial Strategy, is Making Flexible Working the Default. And the closing date for that consultation is the 1st of December 2021. So actually a slightly longer consultation response period than we have been seeing with some of them. And at first, there was a lot of positive noise around this, and people were quite pleased that the government appeared to be taking this quite seriously. But there are a couple of points that I want to make in relation to this. While it is undoubtedly a good thing that the government is consulting on this subject, the concern in some quarters is that this is going to be the short straw, or it's effectively going to be a consultation on the government's terms, and it's not going to involve looking at the whole subject of flexible working as holistically and widely as those of us in practice in this area of law, and indeed those campaigning and lobbying in this space, think is necessary. And instead, effectively, some people have taken the view that this is a bit of a distraction and it actually offers a limited suite of proposed rights. As to my view, well, being circumspect and bearing in mind that I'm currently the Vice Chair of the Law Reform Committee of the Bar Council, and I will be giving this very serious thought over the next few weeks as I prepare the response along with others, it seems to me that there are certainly some proposals that are worth looking at, but I'm not convinced that it goes as far as it needs to. And most of us are probably thinking, well, the acceleration in terms of the changes in the workplace that have happened, indeed the change of the workplace for so many of us due to the pandemic, really make this a unique opportunity to look at a lot of working practices in general. And if we don't seize this opportunity and really try and, well, to use the government's phrase, build back better, it will be a tremendous shame. So just to give you the background to this, and I should add that the consultation document itself is freely available online, in particular from the Department of Business, Energy and Industrial Strategy website. Of course, gov.uk has got a sort of an area of the portal that has all the live consultations. But the background, as is set out, that in 2019, the government's manifesto included a commitment to encourage flexible working and to consult on making it the default unless employees have good reasons not to. And that was something that didn't really take off at the time. There was a task force set up by the government, and that was led by the CIPD. So some work was done into that, but of course COVID-19, which now sounds old, still COVID-21 I suppose, has accelerated, well, I suppose, change of practice on the ground, but also the clamour, as it were, for people to look at this more urgently than was perhaps thought necessary. And in those circumstances, the proposals are effectively to try and improve the existing regime rather than to invent it. Types of flexible working are obviously myriad, so they could include job sharing, where two or more people split a job and the hours. It could involve, as it has for a lot of us, working from home, working part-time or compressed hours, flexi time, staggered hours, and annualised hours. So there's quite a few different ways, and I'm sure there are more besides, in which people can work flexibly. And it's fair to say that they are all types of flexible working which are being considered by the government at this point in time. So here are the things that the government suggests that they might be doing. First of all, the suggestion of making the right to request flexible working a day one right, because at the moment you can't even make the request until you've been there for 26 weeks. And that seems to me to be a fairly uncontroversial proposition. So as I say, at the moment, the provision in the Employment Rights Act 1996 and the regulations made under it for flexible working give all employees, and I should pause there to say that's employees, not workers, all employees a statutory right to ask their employer to change their contractual terms and conditions to work flexibly as long as they've worked there for 26 weeks, and they can only make one statutory request in any 12-month period. There is then a sort of prescriptive process as to how it's done. It has to be done in writing, effectively. There has been notification, and the employer has to consider it. The employer has to do no more than consider it. There's no obligation to accede to it in part or in whole. And if the employer says no to the flexible working request, then the refusal has to be based on one or more of the prescribed business reasons which are set out in the Employment Rights Act. Those are that there will be extra costs that will be a burden on the business. The work cannot be reorganised among staff. People cannot be recruited to do the work. Flexible working will negatively affect quality. Flexible working will negatively affect performance. The business's ability to meet customer demand will be negatively affected. There's a lack of work to do during the proposed working times, or the business is planning structural changes. And it will be immediately apparent to you that those 8 reasons are so incredibly wide that any employer who is minded to say no will find it extremely easy to slot their no into one of those boxes. And the language is pretty nebulous as well. And the degree of inquiry by a tribunal, should someone in fact go so far as to bring a claim, is fairly limited. It's to just find out whether that is in fact the reason and whether the employer has considered the request. So while it is a good thing, most of us would agree that the right to make the request itself should be a day one right, concerns which arise here, and they are concerns which might really affect women who might be displaced in terms of their work during this pandemic. So first of all, it only applies to an employee, so it won't, for example, apply to someone who works in a gig economy worker contract, for example. I know that area of law is obviously developing at a pace quite separately, but unless you are the classic employee, you can't make that request at all. And you can't make more than one statutory request in any 12-month period. So you've got to be very careful as to how you couch that request, because if you don't get it quite right or you want to try different formulations, you might find yourself unable to even bring another request. So day one right, a number of us would say day one right for both workers and employees would have to be a good starting point, and that serious consideration should be given to limiting the right to make that request to one in any 12-month period. The consultation is also looking at whether those 8 business reasons for refusing a request remain valid reasons, and the administrative process which is underpinning it. The government's also considering requiring the employer to suggest alternatives and requesting a temporary arrangement. I should pause there to say that there's no statutory right to a trial period of flexible working. So in a situation where an employer is thinking, well, not so sure about this, might work, but I'm not really sure, they are effectively hamstrung, as is the employee, because there's no trial period which they can undertake unless they agree that separately as a matter of contract under the existing regulations. So the 8 business reasons. Now, the difficulty here is that we need to have a system in which essentially we don't end up with one tier for those who work in offices and in administrative and professional jobs, a lot of the work being done at a desk at a computer, and another tier or system for those who work in the field, in agriculture, in hospitals, in lines of work, in construction, in lines of work in which one has to be physically present at a site, and there are certain physical activities and demands which can't really be undertaken elsewhere. And even in those spheres, there is room for flexibility. But the important thing, in my view, is to ensure that whichever system we end up with, if that's where we're heading, it doesn't end up with a hierarchy of rights, with one sort of gold-plated system, as I say, for office workers, and another one which is not much use for those who work in other professions, industries, and including in the low-paid sector. So I would definitely encourage all of you to have a look at the consultation, whether or not you are someone with caring responsibilities, because as I say, while at the moment it is very much an issue for women who are fundamentally affected by flexible working requests being denied. You may have seen some of the cases that were in the press recently, including the one that was backed by Pregnant and Screwed. But in these situations, it is women who find themselves at the coalface, as it were, of these issues in the workplace, because they bear the burden or the lion's share of childcare burden, and indeed caring responsibilities more widely. And unless we make this the normal for everybody, it will continue to be seen through that prism, and in my view will more than likely contribute to the ongoing economic disparity. And if there's one thing that we women know, it's that economic disparity is a major driving force behind other inequalities, social inequalities and other disparities which women face. So I hope you'll take the time to have a look at the consultation. At the Law Reform Committee, we are always delighted to hear from anyone in relation to any open consultation. And if any of you are particularly interested, Old Square Chambers will be hosting an online symposium on Monday the 18th of October. If you're feeling super keen, please go to our website oldsquare.co.uk and there may well still be some spaces left, and I'll be very happy to see you there. Thank you so much, and I'm so sorry not to be there in person.